It's time for Talk Law Radio with Todd Marquardt. Todd Marquardt, attorney at law in Texas. If you're a millionaire or a thousandaire, Talk Law Radio is now on the air. Call in with your business law question, your elder law question, veteran aid, Medicaid, build a business to get paid. 210-308-8867. Or ask a question online at marquardtlawfirm.com. That's MARQUARDT lawfirm.com. And now it's Talk Law Radio with Todd Marquardt.
Family, fortune, and fallout. When loyalty, love, and good intentions create costly estate planning problems. That's today on Talk Law Radio. I'm Todd Marquardt. But first, let's check in with Jacob Warren with the Financial Focus. He owns and operates Financial Planning HQ with his father and brother. He's been working alongside them for 10 years and is passionate about helping business owners plan their financial success. Jacob loves the outdoors and, most importantly, being a husband to his wife, Catherine, and father to their two kids, Arthur and Camille. Welcome back.
Thank you, Todd. It's great to be here. You mentioned my dad. I want to give him a little bit of a shout out. He's actually watching my kids right now, so hope you're listening and having fun together.
Yeah, thanks, Granddad.
Yeah.
Jacob Warren with Financial Planning HQ. Last time you mentioned that many affluent families have several advisors, but no one leading the process. What does financial leadership actually look like?
Yeah, that's a great question, Todd. So financial success requires financial leadership. So if you think about what financial leadership is, you may not realize that a lot of people don't have somebody running the show when it comes to their subject matter experts. So it's a big gap that we see. Most successful people have assembled a team of experts, right? Think about like a CPA, an estate planning attorney like yourself, Todd, and a financial advisor, somebody that manages your various types of insurance, or if you're a business owner, like a business attorney. Every one of these people is highly skilled and effective at what they do, but there's not one person that steps up to the plate to lead all of these people, to show them exactly what your values, what your goals are, and know that all of these people are helping you get to that end goal that you may have. So that's what we offer to our financial planning clients, is that coordination between everybody. So just to use kind of a practical example, if you think about what goes into building a home, right?
Right.
So you have all sorts of people. You have the architect that's going to design everything, electrician, plumber, people doing the actual work. If those people don't communicate with, say, a general contractor who is overseeing the whole project, I mean, who knows what's going to happen, right? They have to communicate, and they all have to know what the end goal is. They're very good at what they do, but the overarching strategy is something that you need to have a person that's going to be managing that to make sure that you're successful.
Yeah, otherwise they'll mess things up.
Of course, yeah, and that's definitely don't want that.
Can you give us an example of where that coordination makes a real big difference?
Yes. I was actually thinking about this earlier this week because I'm going through this now with a couple of clients. And I'm sure you've heard of Roth conversions, right? Mm-hmm. Roth conversions are kind of a hot topic right now because it makes a lot of sense to do them, but you want to make sure that you're doing it correctly. If you're doing it on your own, something that can happen is you can bump yourself into a new tax bracket. So nobody wants to pay more taxes. So Roth conversions, while they're a great strategy, you need to have some coordination between the person that's actually doing the Roth conversion, say the financial advisor, financial planner, and somebody like a CPA who can come back and tell you, hey, this is where you're at now. And if you take X amount of dollars out of your Roth and do a Roth conversion, you're going to be bumped into a new tax bracket. You're going to pay this much more taxes. We don't want to do that. And what we're doing now, and we work very closely with various CPAs, is we tax project forward to give the clients an idea of what they're going to be paying in taxes. And for our clients that do Roth conversions, we have our CPA actually send us a budget for what they can do this year without affecting their tax status. That's very powerful. It gives the clients a lot of peace of mind knowing that, because I know I can imagine if you're doing them on your own, you're like, okay, I think I can do this much, but you may be missing something. What better person to have than your actual personal CPA come up with that number of what to convert? So I think that's a great example of how coordination is powerful and how you need to have that if you've reached a certain point in your life where you need to have these subject matter experts.
That makes a lot of sense, Jacob. Now, you spend a lot of time helping clients make decisions.
Yeah.
Why are decisions more valuable than just simply picking investments?
Yeah, great question. A lot of people that I meet with the first time, they come into the financial roadmap meeting and they just throw down their investment portfolio.
Right.
And they think that I'm just going to, analyze that and be like, oh, you can do the X, Y, Z. No, so that's not what we do. A lot of financial advisors do operate in that way where you're just kind of looking at the portfolio and looking at moving stuff. What I want to do is I want to understand the individual. And we're going to talk a little bit about the financial roadmap later. But the financial roadmap conversation, we're not even going to talk about money for, say, we're not about money, about your investments until about 45 minutes into the meeting. I want to understand you as an individual because everybody is so different. Everybody has different ideas and plans when it comes to their money, how they want to spend it or who they want to leave it to, things like that. So I need to understand exactly how you feel about money before we even take a look at any of your portfolio. But getting back to the big decisions, over the course of a lifetime, people end up making maybe 4 or 5 huge decisions that make a huge impact on their life. So you think about like when to retire, whether or not to sell a business, what happens if you receive a large inheritance, what happens if a spouse dies early, things like that. So all of these things are huge moments in a person's life, and they can be planned for. You don't have to kind of just shoot through the hip and hope that things work out. When you're working with a comprehensive lifetime financial advisor, all of this stuff is accounted for and planned for. So no matter what happens, say like in the financial markets, or if there's something that happens unexpectedly, you've planned for it and you know that you're going to be successful.
So Jacob Warren with Financial Planning HQ, do you think people underestimate the cost of bad financial decisions?
Yes, 100%. And that's why I'll give you 3 examples of people that I've worked with. One comes to mind. The first one that comes to mind is a retired school teacher, actually, who I just retired this year. Everyone's preparing their classrooms right now, and she's at home relaxing, which is great for her. But we had a meeting about 5 years ago where she was like, Jacob, I'm ready to retire. I'm tired of being a school teacher. I don't want to do it anymore. And then we sat down and we looked at the numbers, and it did not make sense for her to retire. So you can imagine, being the bearer of that bad news was not a comfortable conversation. But I told her, I said, hey, look, let's come up with a 3 and a 5 year plan and see how fast we can make this work. And she said, okay, she's fine with it. And she now has told me, now that she is retired and everything is taken care of and we know that her assets are going to last for the rest of her life, she told me recently that she's glad we had that conversation. If she would have just retired on her own without consulting with her financial planner first, she might have ran out of money when she was in her 80s. And, if she lived a very long life, she definitely would have ran out of money. So that's an example of where you're making this big decision, but you're doing it in a very, very smart way and making sure that you're going to be successful. Another example is a client or a potential client. They actually did not hire me, Todd. And I think about them from time to time because they were in a very unique situation. They were making a lot of money. They had a business,
nice,
a very successful business, and the other one was a very high salaried employee. So they were making well into the mid 6 figures a year. And after I completed their financial roadmap, I noticed you haven't set yourself up for your future at all. You're making all this money, but it looks like you're actually spending all of this money. And at the end of the year, ending up owing taxes and things like that. So they were being a little bit irresponsible with their money. And they were in their mid-50s and they wanted to retire. And I said, hey, this is a pivotal moment. You guys are earning a lot of money. You have a very profitable and successful business. You need to make some changes in order to be successful and retire. And, the reason I think about them is because I think this was probably about 5 or 6 years ago where they could be now. I don't know if they implemented anything on their own. It's hard for people to change on their own. But the reason I think about it is because if I think about it now, we could have made a lot of headway, and I hope that they did something. But that's an example of where indecision and not being willing to kind of take a risk and do something that's good for you can end up costing you in the long run.
Wow, that's a powerful story. I hope everybody's listening and takes notes. You often mention the financial roadmap meeting. What exactly goes on?
A financial roadmap meeting is a meeting where we sit down. It takes about, if you're a married couple, it takes about an hour and 15 minutes. And we talk about money. Money's, like I mentioned earlier, it's very different for everybody. So we'll talk about money, values, goals, and we'll discover if we're a good fit to work together.
Okay, Jacob, thank you for joining me. We'll be right back. Are you confident about your financial future? What if you had a clear financial roadmap and a team holding you accountable to make the best financial decisions no matter what? At Financial Planning HQ, Steve and his sons, Joseph and Jacob, have been helping San Antonio families since 1987 with inspiring, intelligent financial strategies. Whether it's achieving or maintaining financial independence, becoming more tax efficient, or building business wealth, we create a comprehensive, written lifetime financial strategy that's uniquely yours, based entirely on what's important to you. Don't leave your financial future to chance. Call Financial Planning HQ today at 210-685-2722. That's 210-685-2722. And take the first step towards financial clarity. That's Financial Planning HQ, inspiring financial strategies for San Antonio. Remember, 210-685-2722. What if you couldn't speak for yourself? A power of attorney ensures someone you trust can act on your behalf. I'm attorney Todd Marquardt. Let's put your plan in place now. Schedule your free consultation at marquardtlawfirm.com or call 210-530-4278. That's 210-530-4278. Do it before you die. Welcome back to Talk Law Radio. I'm Todd Marquardt. On the radio, on Facebook, on YouTube, and on talklawradio.com. Picture this. A parent gives their child a family house free and clear. Everyone feels generous. Years later, the child sells it and gets hit with huge capital gains taxes that could have been avoided. Or another family member who makes yearly gifts of $19,000 thinking they're completely safe until a parent needs nursing home Medicaid, which imposes a multi-month penalty. Welcome to Talk Law Radio. Today we're talking about legal mistakes people make when giving gifts, specifically the capital gains trap on lifetime gifts and the Medicaid 5-year look-back rule that the annual gift tax exclusion does not override. Let's start with the capital gains problem. When you give away an appreciated assets during your lifetime, a house, stock, land, anything that has gone up in value, the person who receives it generally takes your original cost basis. That's called carryover basis under the tax code. Contrast that with what happens if the same asset is inherited after death. The cost basis is stepped up to the fair market value on the date of death. All that built-in gain that occurred during the owner's lifetime disappears for income tax purposes if the property is sold immediately after death. Here's a concrete example. Suppose a parent bought a house decades ago for $100,000. Today it's worth $500,000. If the parent gives the house to a son or daughter while alive, the child's basis is still $100,000. When the child later sells the house for $500,000, there's a $400,000 capital gain. At federal rates of 15 or 20%, plus possible state tax and the 3.8% net investment income tax, the tax bill can easily exceed $80,000 or $100,000. But if instead the parent keeps the house until death and the child inherits it, the basis becomes $500,000. Sell it for $500,000 and the taxable gain is zero. The difference is enormous. People make this mistake because they only focus on avoiding probate or getting the asset out of their estate. They forget the income tax cost that gets transferred to the next generation. For highly appreciated property, waiting until death is often the better tax result, assuming the estate is not so large that estate tax becomes an issue. And with the 2026 federal lifetime exemption at $15 million per person, most families aren't facing estate taxes. This is Talk Law Radio. I'm Todd Marquardt. We're talking about family, fortune, and fallout, problems that can be avoided when you're making gifts. Now I'd like to talk about Medicaid. The second common costly mistake involves Medicaid. Most people know about the annual federal gift tax exclusion. For 2026, that amount is $19,000 per recipient. You can give that much to as many people as you want without filing a gift tax return or using any of your lifetime exemption. Married couples can effectively double it with gift splitting. The problem is that people assume the same $19,000 amount is somehow safe for Medicaid, but it's not. Medicaid long-term care eligibility has its own completely separate rule, the 5-year look-back period. Under federal law, when someone applies for Medicaid to help pay for long-term nursing home care, the state examines every transfer of assets made for less than fair market value in the 60 months before the application date. Any transfer for less than fair market value, a pure gift, triggers a penalty of ineligibility. The length of the penalty is calculated by dividing the total value of gifts by the average cost of nursing home care in the state that you're in. That divisor varies by state, but is typically several $1,000s per month. So if a parent gave away $95,000 over a few years, and a few years of the $19,000 annual exclusion amount to one child, then applies for Medicaid, the entire $95,000 is added up. Divide by, say, $7,000, the monthly divisor, and you get almost a whole year of an ineligibility. During those months, the family has to pay the nursing home bill privately, which can be devastating. Medicaid does not care that the gifts were under the gift tax exclusion. The exclusion's an IRS rule for gift and estate tax. Medicaid's look-back rule is an anti-impoverishment rule designed to stop people from giving away their assets just to qualify for government benefits. Birthday checks, holiday gifts, helping with the down payment, adding a child to the deed for the house, selling a car for $1, those are all gifts. All of it can count if it happened inside the 5-year window. The only reliable way to avoid the penalty is either to make no uncompensated transfers in the 5 years before needing care, or to plan far enough ahead with strategies that comply with the rules. For example, certain irrevocable trusts created more than 5 years before the application, or legitimate spend-downs on exempt assets. But once the gifts are made inside the look-back, the penalty is almost automatic. A few other gift mistakes that show up regularly are failing to document the gift properly so ownership is clear, forgetting that large gifts still require a gift tax return even if no tax is due, and making gifts when the donor later needs those same assets for their own care. Here are some practical takeaways. First, for appreciated real estate or investments, run the capital gains numbers before you sign the deed. Second, never assume the annual gift tax exclusion protects a Medicaid application. It does not. Third, if long-term care is a remote possibility, talk to an elder law attorney before making more significant gifts. And fourth, keep careful records of every transfer. Medicaid will ask for years of bank statements, deeds, and tax returns. Giving is generous, but the tax and Medicaid rules have sharp edges. The capital gains carryover basis rule can turn well-intentioned house gift into a 6-year tax surprise for your children. And the 5-year Medicaid look-back treats every gift the same. The annual exclusion amount is irrelevant. Plan carefully. Get professional advice tailored to your state and situation so you can avoid these expensive mistakes. This is general information, not legal advice for your specific facts. I'm Todd Marquardt. This is Talk Law Radio. You can find us on YouTube by going to YouTube, click the search menu and type Talk Law Radio, and look for the Lady Justice and the red, white, and blue logo. And click subscribe. That way you can catch all the episodes that are posted. We divide them up into short 10 to 12 minute segments that you can watch or listen to while you're walking the dog, washing the dishes, or working in the garage. You can also find us on podcasts everywhere, of course, Facebook, and talklawradio.com. In fact, if you have some ideas for the show, topics that you'd like to learn about, go to talklawradio.com and click the button that says that you want to be a guest or that you want to sponsor the show. I've been talking about family fortunes and fallout here today, and I just finished talking about lifetime gifts, capital gains, and the step-up in basis after death. I talked about Medicaid for long-term care and nursing home, and the 5-year look back and the penalty that applies if somebody makes gifts within 5 years. If you have questions about these topics, call a lawyer. In fact, Marquardt Law Firm sponsors this show, and you can call a lawyer at Marquardt Law Firm by dialing 210-530-4278, 210-530-4278, or go to marquardtlawfirm.com. That's M as in mother, A-R-Q-U-A-R, D as in David, T as in Timothy, lawfirm.com, and schedule an appointment to talk to a lawyer about your goals and concerns, and they'll tell you if we can help. In the next segment, we're going to be talking about power of attorney and the problems that can happen there. And then we'll be talking about legacy, including what the family limited partnership is used for and how it might help, and all the problems that could happen if you set it up the wrong way or at the wrong time. So let me just recap what we learned this segment. We were talking about gifting, making lifetime gifts to your beneficiaries or your children during your lifetime, and the problems that it could create for them if you give a highly appreciated asset to them, like stocks or a house, and then they sell it and they have to pay capital gains tax. But if they can wait until after you pass away, you get a step up in basis and you save, and that child saves income taxes. They don't have to pay capital gains. Now remember that if you're making gifts in order to qualify for nursing home Medicaid, the IRS gift tax and estate tax annual exclusion amount of $19,000 per person per year doesn't matter. Medicaid doesn't care about the gift tax and estate tax annual exclusion amount. Medicaid and the IRS rules and regulations are completely separate. That's why it's best to do gifting under the care and supervision of an attorney or accountant that knows both sets of rules. Okay, so you've been listening to Talk Law Radio for a long time now, but have you shared it with your friends? You want them to know what the hidden legal issue blind spots are as well, because if they step into a legal blind spot, they might drag you in with them. I'm Todd Marquardt. This is Talk Law Radio. Been talking about lifetime gifts, after-death gifts. In the next segment, we'll be talking about power of attorney and problems that could be prevented. Stay tuned. We'll be right back. Family loyalty is powerful, but the tax code, the Medicaid rules, and fiduciary law is more powerful. This is Talk Law Radio. I'm Todd Marquardt, and it's time for the sinners and the saints. A mighty fortress is our God. I love this song, especially the organ music, traditional church music. Well, this is the segment where I start talking about sinners and saints, because Martin Luther said that we're all sinners and saints, but because of the death and resurrection of Jesus Christ, we're saved and absolved. So this week, I'm going to be talking about power of attorney. You signed your power of attorney. You named someone to handle your money, your house, and your bills if you become incapacitated. The question every family member should ask is my agent a saint or a sinner? Welcome to Talk Law Radio. Today we're talking about the most common myths families believe when they choose an agent under durable power of attorney. Myths that too often lead to financial elder abuse, family fights, and ruined estates. First, a reality check. A financial power of attorney gives your agent enormous power. They can write checks, sell real estate, manage investments, even change beneficiaries in some cases. In return, the law imposes strict fiduciary duties. The fiduciary duty is the highest duty imposed by law. They must only act in the best interest of the principal. Keep careful records, avoid conflicts of interest, and never use your money for their benefit. When the agent is a saint, it works beautifully. When the agent is a sinner, damages can be irreversible, and it happens so quietly while the principal is sick or confused. So choosing the right person is one of the most important decisions you will ever make. Now let's bust the three biggest myths. Myth number 1, I should appoint my oldest child. They're the firstborn, so they're a natural leader. Reality, birth order is completely irrelevant. Competence, integrity, and financial responsibility are what matter most. The oldest child may live across the country, have a messy divorce, or struggle with debt, or simply lack the temperament to handle money carefully. Meanwhile, a younger child may be the one who's organized, trustworthy, and geographically available. Courts and elder law attorneys see this myth play out over and over again. Families default to the oldest out of tradition or fear of hurting feelings. Then watch as the oldest agent makes poor decisions or worse, steals the money. Choose the person who's best qualified, not the person who arrived first. Myth number 2, my daughter quit her job to take care of me. She deserves to be the agent, and she's here every day. Reality check, providing hands-on care is wonderful and often crucial and sacrificial, but it does not automatically make someone a good financial agent. In fact, it can create conflicts. The caregiving child may may feel entitled to compensation and start writing checks to themselves. They may be under financial stress because they left the workforce, or they may simply lack the skills to manage investments, taxes, and real estate decisions. Elder financial abuse statistics show that family caregivers are among the most common predators, not because they set out to be sinners, but because the opportunity and stress collide. If you want to compensate a caregiving child, maybe use a written personal care agreement reviewed by a lawyer. Do not hand them the keys to the entire financial kingdom just because they're the one bringing the meals and changing the bandages. Here's myth number 3. My son disappeared for 15 years, but he came back. We reconciled, and now I want to show him that I trust him by making him my agent. Reality check, this is one of the highest risk choices you can make. Sudden interest in an aging parent's finances after a long estrangement is a classic red flag for exploitation. The prodigal child may have returned because money is running low, because the other siblings have stepped up, or because they see an opportunity. Past patterns of irresponsibility, addiction, or broken trust rarely vanish overnight. Courts repeatedly deal with these cases where the long-lost child is named agent. The parent becomes incapacitated, and within months the accounts are drained. Reconciliation is beautiful, but handing over legal control of every asset is not the way to celebrate it. If you want to include the prodigal child, consider limited powers, co-agents, or a professional fiduciary instead. So how do you find a saint and guard against a sinner? Ask hard questions. This is Talk Law Radio. I'm Todd Marquardt. Today we're talking about family, fortunes, and fallout. In the second segment, we were talking about gifting and the laws and regulations that the IRS imposes, that Medicaid imposes when you apply for nursing home Medicaid to pay the high cost of long-term care. And in this segment, we've been talking about sinners and saints, how to choose a power of attorney agent that's right for you. Here are some hard questions you should be asking yourself. Does the person that I trust the most handle their own money well? Are they organized? Are they honest? Do they live nearby, or are they willing to travel? Do they know how to use the internet? Do they keep their cell phone charged? Can they say no to other members of the family who pressure them to make gifts? Are they willing to keep detailed records and report to someone else? Consider naming co-agents who must act together, or require the agent to make an annual financial accounting to a successor agent, or just name a professional fiduciary like a bank. In some cases, a professional fiduciary, bank, or trust company is the safest choice, even if you have to pay them. And remember, you can revoke or change a power of attorney, but only so long as you have capacity and so long as you're alive. So review it every few years, and when you see your agent at Thanksgiving or Christmas or birthday or other family reunion moments, think to yourself, do I trust this person? Are they honest? Are they organized? Are they going to make good decisions? We have a caller live on the air. Sean, welcome to Talk Law Radio.
Hey, yes, sir. Thank you. Good afternoon, morning, afternoon, whatever it is.
What's your question?
Basically, I was explaining to your screener, and I don't know if there's a recommendation you can give us. I'm a funeral director in Texas, and we see power of attorneys that expire. I mean, once death occurs, the power of attorney is not valid for funeral arrangements, and the families think they are. The durable has to list To the best of my knowledge, the durable power of attorney has to list that they have the powers of disposition. But most people just have financial or medical power of attorneys. I don't know what type of information to give to families whenever they're drafting these things up with their attorneys.
That's a great question. There is a different form called disposition of remains where they can say what they want. I shall be cremated or I shall be buried, and then name an agent to carry those wishes out. So that's a great point.
Okay, so that's the appointment of disposition?
Yeah, I call it disposition of remains.
Disposition of remains, okay. Yeah, because I know we have that form, and then whenever somebody, I know there's lots of ways around everything, but it's an actual, for you guys, it's going to be an actual different form, the same way that it is for us then. Yes,
and you're absolutely right. The durable power of attorney expires upon death. And I've seen lots of families, they fight the hardest about who's going to get the ashes.
Yeah, yes, they do.
Well, thanks for the call. We got to take a commercial break. Thank you for calling in. Where are you calling from?
So we're based out of Seguin.
Okay. Yeah, well, I'd like to catch up with you sometime. So call me at Marquardt Law Firm, 210-530-4278, and we can talk more.
Perfect. Thank you so much. You have a wonderful day.
Talk to you later. Okay, so we've been talking about power of attorney this segment, and we just had a wonderful caller make a great point about how the durable power of attorney expires upon death, and that you can decide whether you want to be buried or cremated and appoint somebody to dispose of your remains. That's a fancy way of saying that you're going to be buried or cremated. Well, we got to take a break. Next segment, we'll be talking about legacy, so stay tuned. Are you 100% confident that no matter what happens in the financial markets, economy, or world events, you will achieve your financial goals? If not, we have a process to get your financial house in perfect order and keep it that way forever. Your financial future shouldn't be a guessing game. Planning, advice, organization, and accountability are deliverables you should expect. For over 35 years, Financial Planning HQ has been San Antonio's trusted partner for comprehensive written lifetime financial strategies. Steve and his team, including sons Joseph and Jacob, don't believe in a one-size-fits-all approach. Instead, they create a personalized financial roadmap for you based on what's important to you. As an independent registered investment advisor, they're not tied to any big corporation's products. They work for you, creating inspiring, intelligent financial strategies that put your interests first. Call Financial Planning HQ at 210-685-2722. That's 210-685-2722. What if you couldn't speak for yourself? A power of attorney ensures someone you trust can act on your behalf. I'm attorney Todd Marquardt. Let's put your plan in place now. Schedule your free consultation at marquardtlawfirm.com or call 210-530-4278. That's 210-530-4278. Do it before you die. Welcome back to Talk Law Radio. I'm Todd Marquardt. Today we've been talking about family, fortune, and fallout. In the second segment, we were talking about IRS rules and Medicaid rules for making gifts and taking exclusions and paying taxes. In the third segment, we talked about the sinners and the saints, how to appoint somebody to be agent under your power of attorney. This is the legacy segment.
And now, it's time for the Talk Law Radio Legacy Spotlight. What's your legacy? Sponsored by Marquardt Law Firm.
Marquardt Law Firm sponsors the show, and attorneys at Marquardt Law Firm focus on business and estate law, including last wills, living trusts, and tax-protected inheritance plans. It's all about legacy. So this segment is going to be about leaving a legacy through a limited partnership. That's a business entity that's created sometimes to help with estate planning. Imagine this. A family transfers $17 million into a limited partnership just weeks before the elderly relative dies. On the estate tax return, they list the value of the partnership interest at about only $11 million, a $6 million discount. The IRS says, not too fast, and the tax court agrees. And this past June, the Fifth Circuit Court of Appeals affirmed. Welcome to Talk Law Radio. Today we're looking at a real-world case study of one of the most popular and most heavily scrutinized estate planning tools, the Family Limited Partnership. Let's start with the basic idea. Federal estate tax currently applies to estates above a very high exemption amount. Still, for larger estates, the tax is 40%. So every dollar you can legitimately keep out of the taxable estate saves real money. One classic technique is to place assets, real estate, investment, business interests into a limited partnership. How this is accomplished is much more important. Get legal advice. The older generation keeps a tiny general partner interest that controls the entity and gives or sells the bulk of the limited partnership interest to the next generation or to a trust. Because limited partner interests lack control and marketability, appraisers often apply substantial valuation discounts, sometimes 20, 30, 40%. You have to do this under the care and advice of attorneys, accountants, appraisers, and financial advisors. The theory is that the estate only includes the discounted value of the partnership interest, not the full value of the underlying assets. Congress and the courts have long recognized that these discounts are available if the partnership is real. The key statute is Internal Revenue Code Section 2036. It pulls transferred assets back into the gross estate unless the transfer was a bona fide sale for adequate and full consideration. Courts interpret that to mean the partnership must have a substantial non-tax purpose, something more than just reducing estate taxes. Now we're going to talk about the estate of Ann Milner Fields. Mrs. Fields was a successful businesswoman who had run her late husband's oil business for decades. By 2011, she was diagnosed with Alzheimer's. Her health declined steadily. Her great-nephew, Brian Milner, a financial professional she had mentored, held her power of attorney and was named executor of her will. In May 2016, Mrs. Fields' condition took a sharp turn for the worse. She fell, suffered a heart attack and spine fracture, was hospitalized, and by early June, her doctor declared her Alzheimer's end stage and recommended hospice. She died on June 23rd. In that same narrow window, from mid-May to mid-June, Milner, acting under the durable power of attorney, created a limited partnership called A.M. Fields LP. He formed a management LLC that he controlled as the 1% general partner. Mrs. Fields, through Milner, contributed roughly $17 million of assets, memberships in 2 LLCs she owned, a tree farm, bank stock, and nearly $10 million from a brokerage account. The partnership agreement gave her a 99.994% limited partnership interest. After her death, the estate tax return reported that limited partner interest at only about $10.9 million. The difference, roughly $6 million, was claimed a valuation discount. The estate tax bill was reduced accordingly. But the IRS audited, dun dun dun, applied Section 2036, included the full value of assets, and added a 20% accuracy-related penalty. And the tax court upheld both the deficiency and the penalty. On June 8, 2026, the Fifth Circuit panel affirmed the decision. The only real issue on appeal was whether the transfers were qualified as a bona fide sale. The court treated that as a pure factual question. Did objective evidence show a substantial non-tax purpose that actually motivated the partnership? This is important, so listen up, sharpen your pencil, get your pen out, and take some notes here. Did objective evidence show a substantial non-tax purpose that actually motivated the partnership? The estate offered 3 reasons. First, the power of attorney had succession and management problems. Financial institutions sometimes balked at the aging power of attorney. It was a very old document. And the successor agents, Milner's sisters, supposedly weren't comfortable handling the finances. Second, the assets needed to be consolidated and streamlined under expert management. Third, the partnership would protect against elder financial abuse. But the Fifth Circuit, like the tax court, found all 3 reasons unpersuasive. The power of attorney succession argument was undercut by the fact that Mrs. Fields herself had chosen the successors when she was competent. And the partnership documents didn't actually solve the succession problem. As for institutional resistance, Milner had just used that power of attorney to move $17 million in a matter of weeks with no apparent difficulty. And there was almost no contemporaneous evidence of continuous problems. The consolidation argument failed because the assets weren't operating businesses that needed active management. The brokerage account was already professionally managed. The bank stock paid dividends and mostly just sat there. The tree farm had been managed by a local company for decades. There were no synergies from pooling these resources together into the partnership. The elder abuse protection claim was weakest of all. The 2 documented incidents had occurred in 2011 and 2013, years earlier. So here's the lesson. Waiting until Mrs. Fields was in end-stage decline made the timing look like a deathbed tax play rather than genuine asset protection. The court also listed a series of troublesome facts. The extremely compressed timeline, the complete absence of any partnership discussion until her health was failing, the email from the estate planning attorney seeking a deeper discount, the fact that Milner signed on both sides of every transaction while Mrs. Fields was incapacitated, and that the transfers left the estate short of liquid cash to pay the specific bequests in the will. In short, the non-tax reasons looked like after-the-fact justifications, not actual motivations. Section 2036 of the Internal Revenue Code therefore required inclusion of the full asset values. On the penalty, the court held that a $6 million valuation drop should have looked too good to be true to a financial professional like Milner. Simply hiring professionals is not enough. If there's no evidence, they specifically advise that the discount treatment was proper. The reasonable cause defense failed. This is Talk Law Radio. I'm Todd Marquardt. Today we've been talking about family, fortunes, and fallout. In the second segment, we talked about gifting during your lifetime or waiting until after death. We talked about the tax implications, capital gains, stepped-up basis, carryover basis, and the Medicaid rules if you're trying to qualify for nursing home Medicaid. In the third segment, we talked about sinners and saints, how to choose somebody to be your agent under power of attorney. It's so important. It's one of the most important decisions you'll ever make. So make sure that it's correct and get advice from a lawyer. In this last segment, we talked about the limited partnership, valuation discounts, and what factors are important. I'm Todd Marquardt. This is Talk Law Radio. Tune in every Saturday morning and also Sunday afternoon. In fact, tune in tomorrow to hear about how the AI agent escaped from its sandbox. Stay tuned, or tune in later. I'm Todd Marquardt. Talk to you later.